વિકેટ ત્યાં જતા રમવા. બંને ખબર છે ને 12 મિનિટનું કરેલું છે. કેટલું જાણે જવાનું?
આમનો ભાઈ બોલ કઈ માહિતી જરૂર આમનો બોલ આવી જશે
અવાજ જ એવો છે કે
મમ્મી હરવરનો નાસ્તો કરાવી મૂક્યો.
જો ચાલ.
Just visualize a situation. If four major petrol supplying companies join their hands and increase overnight the price of petrol rupees 100 per liter, what will we do? हम क्या करेंगे? Similarly, just imagine a situation if all PND suppliers get combined into one single giant company. How badly they can take undue advantage from the public. How badly they can abuse their dominant position. ज्यादा सोचने की जरूरत नहीं है. कंपटीशन एक्ट जो है हमको मदद करने के लिए आ गया है. Good afternoon to all the present. This is Sanket Kanabar and I shall be with you for some time on the topic Competition Act, a tool to put fetters on monopoly. The Competition Act has been playing dual role. One is to put fetters on monopoly, and second, it fosters competition. The Competition Act 2002 has repealed the MRTP Act 1969. Now, I know you will ask question that when MRTP Act was already there, what was the need of this new act? Yes, your concern is quite genuine. In the light of the changing situation, Finance Minister of India in its budget speech in February 1999 has made the statement that the MRTP Act has become obsolete in certain areas in the light of international economic developments relating to competition laws. We need to shift our focus from curbing monopolies to promoting competition. The government has decided to appoint a committee to examine this range of issues and propose a modern competition law for suitable for our country. The Raghavan committee was constituted to recommend a suitable legislative framework relating to competition law for our country. One of the biggest failings of MRTP Act was lack of adequate remedy to complainants. Except cease and desist, there was no other penalty or fine that could be imposed. Secondly, the MRTP Act did not provide for extraterritorial jurisdictions, whereas the Competition Act is applicable beyond the geographical boundaries of India. Thirdly, the MRTP Act did not define certain key terms such as abuse of dominance, collusion, bid rigging, collusive price fixing, predatory pricing, etc. Finally, the Raghavan committee advised for the enactment of a new Competition Act. The Competition Act 2002 was passed on 13 January 2003 and subsequently in 2007 and 2009 it was amended. Further, again in 2012, Competition Amendment Bill 2012 was passed. Now, broad objectives of Competition Act has been classified under three main heads. First, prohibition of anti-competitive agreements under Section 3. Second, prohibition on abuse of dominant position under Section 4. And third, regulation of monopolies and combinations under Section 5 and 6. First of all, we must know what can be termed as anti-competitive agreement under this Act. All agreements which cause or are likely to cause an appreciable adverse effect on competition within India shall be termed as anti-competitive agreements. Such agreements are further subclassified under two agreements, namely horizontal agreements and vertical agreements. Horizontal agreements. Such agreements are between and within the competitors which are at the same stage of supply, distribution, production, etc. Such agreements are presumed to be illegal. Example, cartel, bid rigging, sharing of markets, etc. Vertical agreements. Such agreements are between the parties which are at the different stages of supply, distribution, production, etc. These are not presumed to be illegal but are subject to rule of reason. Example, refusal to deal, tie-in agreements, etc. Here, horizontal agreements are presumed to be illegal and are viewed more seriously. Here I would like to quote a judgment in case of Builder Association of India versus Cement Manufacturers Association and 11 cement manufacturing companies, wherein penalty was levied as high as rupees 6,300 crores. Yes, in the year 2010, an information was filed by the Builders Association of India against Cement Manufacturers Association and 11 major cement manufacturing companies. It was for the alleged violation of the provision of Section 3 and 4 of the Act. As per the informant, the opposite party under the umbrella of Cement Manufacturers Association directly and indirectly indulged into monopolistic and restrictive trade practices and made an effort to control the price of cement by limiting and restricting the supply as well as production of cement against the available capacity of production. They were also indulged in collusive price fixing. They had divided the entire territory of India into 5 zones so as to enable themselves to control the supply as well as to determine or fix exorbitantly high prices of cement by forming cartel in contravention of Section 3 of the Act. Finally, huge penalties were levied among them. ACC Limited 1,147 crores. Ambuja Cements Limited 1,163 crores. Jaiprakash Associates Limited 1,323 crores. Ultratech Cements Limited 1,175 crores. Lafarge India Private Limited 490 crores. Binani Cements 167 crores. JK Cement 128 crores. And lastly, Cement Manufacturers Association 73 lakhs. The second objective of the Competition Act is prohibition of abuse of dominant position. Dominant position is defined as a position of strength which enables the enterprise to operate without any independence at the independence of the competitive forces in the market or to affect its competitors or consumers in its favor. There is no mathematical or statistical formula, nor there is any threshold limit to measure the dominance. Again, simply having dominant position will not track this section. There must be abuse of this position. Here, it will be interesting to look into the case of Sri Shamsher Kataria versus Honda CL Car India Limited and others. Sri Shamsher Kataria had filed an information against Volkswagen India, Honda India and Fiat India against the violation of provision of Section 3 and 4 of the Competition Act 2002. It was alleged by this informant that the above mentioned original equipment manufacturers entered into agreement with original equipment suppliers and authorized dealers which charged unfair prices of spare parts supply as well as they restricted the free availability of genuine auto spare parts in the market. Further, the original equipment manufacturers charged exorbitantly high prices to consumers for maintenance as well as for supply of auto spare parts. Finally, the result was that 14 automobile manufacturing companies were imposed a penalty and were found guilty of anti-competitive practices. The penalties were Tata Motors 1,346 crores, Maruti Suzuki 471 crores, Toyota Kirloskar Motors 93 crores, Honda CL 78 crores, Mahindra and Mahindra 292 crores, and the remaining penalty is between the companies like Mercedes-Benz, BMW, Ford, Toyota, amounted to around 175 crores. थर्ड ऑब्जेक्टिव जरा हटके है. यहाँ CCI प्रोहिबिट नहीं करती मगर रेगुलेट करती है. It's regulation of combination, consolidation, merger. That is, it's regulation of combinations. Here, CCI is expected to regulate the combination. That is, large mergers and acquisitions which are likely to cause appreciable adverse effect on the competition within India. Here, I would like to say that even in case of merger of Holcim Group with Lafarge Group as well as Jet Airways with Etihad Airways, cases were lodged against these brands under Section 5 and 6 of the Act. आपको लगता होगा कि Competition Act ने तो किसी को नहीं छोड़ा. No, there are exceptions. Nothing contained in this Act shall restrict any person to restrain its infringement or to impose reasonable conditions as necessary to provide his rights which may be conferred or which have been conferred under Patent Act, Trademark Act, Copyright Act, Geographical Indication of Goods Act and Designs Act. अब आप ही बताइए, except exception specified, is there any possible situation left out which is anti-competitive? No. No possible combinations are left. Even state-owned enterprises, government institutions and such other institutions have also been prosecuted and penalized under this Act. Example, BCCI and Railway. BCCI was imposed upon a penalty of rupees 52.2 crores by the CCI. Also, by the virtue of the judgment of the Supreme Court, Competition Act shall also apply to Railway Ministry. अब अगर किसी को CCI को information देना हो तो what is hierarchy? Yes, CCI handles the administrative part. If agreed by the CCI, you can approach the COMPAT, that is Competitive Appellate Tribunal. And if further agreed, you can approach the Supreme Court of India. क्या आप लोगों को नहीं लगता कि हमारे पास बहुत अच्छा एक्ट है, लेकिन इसकी अवेयरनेस नहीं होने की वजह से जनरल पब्लिक इसका पूरी तरह से फायदा नहीं उठा पाती? It's our duty as a student of a professional course to create more and more awareness regarding this so that due advantage can be availed by all the Indians. Thank you for patient hearing.